Well, welcome to Spokane Talks News Matters, and I have with me Chester Baldwin from the, let me get the name of the organization correct, Washington Business Property Owners Association?
Yes, Washington Business Properties Association, WBPA.
Okay, WBPA. And we're talking because your group is planning to or has filed a lawsuit to follow up on a real catch-22 situation that landlords have been put in by the state legislature. Is that a correct characterization?
Yes, that is a correct characterization. And so I believe that lawsuit will be filed today here in Spokane Superior Court.
Okay, so give me a rundown on just what the situation is that led you to filing this lawsuit.
So, the Washington Business Property Association is a group that's made up of residential, commercial, and retail real estate. So we're sort of a very broad tent where anyone who's concerned about real estate can be a member, and we try to deal with some of the bigger issues we have out there. And so, we've been very involved in trying to make sure that small housing providers continue to provide housing in the state, and we don't see them leaving in large numbers. And, during the last 2 years with the governor's eviction moratorium during COVID and the other things with the pandemic, we saw a large exodus of our small housing providers across the state, mostly evidenced by the reports that come out of Seattle, because they have a registration program so they can actually show how many units left. And using Seattle as sort of a bellwether across the state, we lost somewhere in the neighborhood of 12% of all of the single family homes in the rental market in the last 12 months. And so we're seeing housing providers just leaving because they can no longer be in this business and be able to do that with a reasonable level of certainty or with any financial knowledge of how much it's going to cost, because of some of the laws that we've passed in Olympia the last few years that are drastically increasing the cost to be a housing provider, and therefore drastically increasing the cost of housing.
And I know one of the things people don't think about is that those owners of single family homes that are renting those out, those are the homes that are most sought after by families, by larger families, by multi-generational families. They don't fit into a typical kind of apartment setting, and when those leave the market, that really removes a whole lot of options for a big chunk of the renters.
You're 100% right. Like, if you look at what, we are building new units in this state, at least some, especially because of the multifamily tax exemption that was passed a couple of years ago. But most of those units are apartments, and a lot of those apartments are studios and one bedrooms. And so you're exactly right. If you're a family and you need a rental house, the options are dwindling, and it's getting harder and harder, especially with, and there's two things coming together. I don't want to put all of this on just the eviction moratorium and all of that on small housing providers, but when you couple that with a red hot real estate market where single family homes are flying off the market, and I know it's cooled just a little bit lately, but those people who have been housing providers for 30 or 40 years, and they see all these laws coming and they just wonder, how am I going to be able to comply with all of those? And then they see a red hot real estate market and they say, well, maybe now is the time that we finally sell this. And when those homes sell, especially around the state in some of our populous areas, the rate that the home sells for now won't support a rental. Take King County, $900,000 on average. But even, I live in Olympia, even Thurston County, we're above $400 and something thousand for a median home, and there isn't any. The biggest problem is that we have no homes. And I don't want to get too far afield, but our problem in the state is that we have a serious housing crisis and a lack of housing, and yet we're not building more of it. We were short more than 250,000 housing units before COVID, and we've had more people move into this state during COVID and because of COVID, and yet not only are we not building more housing, we're putting more cost and regulation on housing providers and thinking somehow affordable housing is going to come out the other side. And we are going to be very, very sorry when we realize how much we've done to destroy our housing market in this state.
Right. And you mentioned the people who've owned these houses and been running them as property managers for 30 to 40 years and looking at maybe this is time to cash out. That's the last bit of the baby boom wave, right? People who are ready to retire, and this has been their living, and that basically is their retirement savings, is that value. So it's time. The timing is there.
Yeah.
You're
exactly right. And
go ahead. Go ahead.
I was just going to say, but I work with the Rental Housing Association of Washington and the Washington Landlord Association as well. Each one has about 5,000 members, and on average, those people own 2 units. So that's their home and 1 more unit. And so when they then see all these laws come in and they have to try to figure out how they can continue running their business while they all, they're not full-time landlords. They have jobs, and they just, over the course of their life, they might have moved up from their starter home to another home and then chose to rent that starter home, or whatever the case may be. But they're not sophisticated attorneys or good with dealing with the level of regulation that we've created in this state on small housing providers.
Right. That could set us off on a whole other tangent. As you increase the bureaucratic tangle, we increase the chances that things become more corporatized, because we make it impossible for the small business or the small landlord to do it. So we'll set that aside for a moment. And there is a particular catch-22 that's been developed that is the basis of this lawsuit, and that is it has to do with a requirement that disputes go to a dispute resolution center before they can go to court. But there's a problem with that, and I'm going to let you describe what some of that problem is.
Thank you so much. So the legislature in Olympia passed a bill that, coming out of COVID, requires housing providers to give some specific notices and then go through mediation with the dispute resolution centers before they're allowed to even go into court. They have to get this certificate from the dispute resolution center saying that they've participated in mediation. It is our belief, and the basis of this lawsuit, that the dispute resolution centers are failing to meet their obligation to issue those certificates, and are in fact choosing not to issue those certificates in a timely manner in a lot of cases. And that has caused the inability to even access the courts. And that is a big issue for us, because access to the courts is the bedrock foundation upon which all of the rest of people's rights and obligations work. And we have, for decades and generations, defended the right to have access to the courts for everyone. And then with this law, we have effectively closed off the courts unless this third-party non-government agency agrees that you can go to court. And if they just choose not to issue that certificate for whatever reason, even if you've materially participated in their dispute resolution, well, there's nothing you can do. You can't go into court, because you can't get to court until you have that certificate. And that is the basis for the lawsuit that we are going to be filing on that.
Okay, and I understand one of the issues with that dispute resolution, with that mediation, is that there's really no way to compel the other side. I mean, the landlord can go in, but if the other side doesn't show up, there's nothing much they can do about it. Is that correct?
Yeah, and the process you're exactly right. The process has always been, until now, if we show up and we do our part and the tenant chooses not to participate, we have met our obligation and we can move forward. Well, that is not happening with the dispute resolution centers. They are choosing to be judge, jury, and determiner of fact. And so at times when the tenant doesn't show up, they just reset it. Or an attorney who represents the tenant might be there without the tenant, and they'll allow that to be continued. And they push these things out time and again. And what they don't understand is that the people who are being harmed by that are the tenants. Because as you're pushing this thing out weeks and weeks and months, the amount of money that they owe for rent is continuing to increase. And the unlawful detainer process has historically been in this state an expedited process on purpose. We are guaranteed a hearing within 30 days because it is about the possession of real property. And that those things have always been seen by the court as something that's of primary importance. And so it gets priority. We're not getting priority anymore. And not only is it not priority, but getting pushed to the back of the line. And it's part of the reason you're seeing so many housing providers just decide, I can't go through this labyrinth of bureaucracy to try to get my unit back so I can rent it. And I can no longer continue paying the mortgage without the rent that the tenant is supposed to be paying. And so they have no choice but to sell the unit. And we lose another housing unit from our already low rental housing inventory in the state.
Okay. Well, we'll have to follow the progress of this lawsuit as it goes through, and invite you back for an update when hopefully it doesn't get as drawn out as the process has become through the dispute resolution centers.
No, we hope to get that resolved quickly, and we would love to work with the other side to find a workable solution for everyone. We just need an actual court process that can work, and we need to be able to avail ourselves of the rights of being able to go to court, which everyone should have as their fundamental right.
Right. I've been a part of alternative dispute resolution in the construction setting and mediation, and I think those processes can be very helpful. But if it's becoming a barrier to getting any finalization, then there is a problem there. We'll have to see what the courts has to say.
Yeah, and we don't mind, we were advocates for working with the dispute resolution centers originally because of the fact that we needed some help, and we thought they would be a very a good partner in working through those things and help to support that housing partnership that we have in this state between the small housing providers, the tenants, and the state, making sure that we can all work together to keep people housed. And so, we're disappointed in how that went. And, we thought we would get a fair and equitable process for that to work that could give people the due process they need to be able to get into court, but also to help those people who need rental assistance to be able to get that as part of the process. That was the goal. It's just not working out that way, just the same way that the rental assistance rollout did not go anywhere near the way that we had hoped either.
Okay. Well, thank you for joining me today, Chester, and I look forward to checking back in with you later.
Thank you so much, and you have a wonderful day.